Good morning, Mr. Conant.
Good morning, Your Honor.
Looks like we've got audio connections with everyone. Shannon, you can put us on the record now.
Okay.
Okay, this is Walker versus Walker. Mr. Conant representing plaintiffs, correct?
Correct, Your Honor. Curtis and Deborah Walker.
I thought so. Your motion says attorney for defendants. That's what threw me. That's all right. I figured it out. All right. And I have three other persons in the courtroom. I need each of you to identify yourselves. Let's start with Mr. Mustache first. Can you hear me, sir? With the striped shirt and the mustache, can you hear me? All right, check your settings. Something's obviously amiss. Ma'am, on the iPhone, what is your name?
Deborah Walker.
And I have someone on a Fire tablet. Could you identify yourself, please? Well, looks like we got connection problems today. I'm trying to figure this out. Sir in the striped shirt, can you hear me now? Well, it doesn't sound like he can. Mr. Conant, can you tell me who that is?
I'm not sure. I had invited Curtis Walker and Deborah Walker to attend. Deborah's here. Curtis probably is, but no response. I'm only seeing you, myself, in the empty courtroom. I saw Deborah when she acknowledged her presence.
How you doing, Jen?
Oh, great. We got a connection.
Curtis.
I'm sorry.
That's Curtis.
So Curtis
Walker's
present.
in the stripe, yeah.
Deborah Walker's present, and somebody's on a Fire tablet. That's all I see is Fire tablets.
Hello.
I'm sorry.
Can you hear me?
State your name, please. I can.
Booker
State your
Walker.
name, please.
Booker Walker.
Okay. Mr. Booker Walker is present. Mr. Conant, this is your motion.
Thank you, Your Honor. Your Honor, the court entered a judgment back on January 12th. Looks like it maybe got mailed out on the 14th of January. It determined that Mr. Booker Walker, the defendant, should turn the key to 2014 Merriman Street over to myself. He's failed to do that. I've called. I've requested the key. I've gotten into arguments with him that have not been very beneficial. Still don't have the keys. I think I've gotten several calls this week that sounds like he probably wanted to give me the keys before today's hearing, but based on my past history with him, I thought, well, it's best that we'll just get this taken care of in court. He's caused me to incur additional expenses for my clients. They shouldn't have to incur. He's also at the very end of his 30 days to pay up what he was ordered to pay pursuant to the terms of the judgment. He accused me of being the one that prepared this judgment, which obviously the court prepared. So.
Okay, Mr. Booker Walker.
Yes.
Are you willing to turn the key over?
Yes, but I would like to have a little conversation about concerning that as to why I have some reluctance to do that. Can I do that? Am I allowed to do that?
You may speak. Go ahead, sir.
Okay. I attempted to contact the realtor to ascertain the terms of the agreement, which I had never signed or was even, I was aware that it had been made with that real estate company. However, I was not abreast to what the terms were. And when I asked the realtor, finally he got a hold to him. I tried, I don't know how many times, dozens of times, because his office where I called was closed because of COVID. And then finally someone answered the phone and told me they would have him to call me. His name is Dan Berlin. He called me and I asked him, what were the commission rate attached to this property? He tells me, well, we don't have one. I said, what, you don't have a rate that you're using? No. We have a flat fee of $3,500. I said, oh, isn't that kind of unusual? They usually have a rate, percentage rate, like 5, 6, 7%. Usually, he said, well, we don't have that. We got a flat fee. I said, well, why is that? He tells me I have to do what my attorney tells me. Now, I did some research about that rate. And in this community, the rates are 5, 6, 7%. I was attempting to converse with Curtis and Deborah about the rate that they negotiated. Mr. Coyne, let me finish, please. And when I called Mr. Coyne,
Mr. Coyne wasn't the one that interrupted you. And please, just a second, sir. Ma'am, do not interrupt. I'm going to put you on mute. If I need to hear from you, I will ask you to unmute. I'm sorry. Go ahead, Mr. Booker Walker.
So, and when I did converse with Mr. Conan about the key, and I was attempting to ask him about the rate that was being applied to the transactions on the house with the real estate company and what we had to pay as a commission. I got no response. The only thing he said was demanding the key. Bring me the key. Bring me the key. Every time I talked with him, that's all he would say to me. Bring me the key. I did not think that was a fair or a reasonable rate that we had to pay for that to sale of the house, because it's way above what is normal for this area. And then also, Mr. Verlin said, well, that when we evaluated the property, we came up with a price of $43,000 a top. I did the math, and a rate of 7%, which is normally the top in this area, from what I found from 3 or 4 other realtors, that was above that. I was going to ascertain why was it so much higher for our property if you put it on a percentage basis. This is where the conflicts come in. I could never get an answer. Every time I talk to Mr. Coyne, all they would do is demand that I do this. You do this. You do that. Give me this. And I'm sorry we got to that position, and maybe I'm wrong, but I do have a right to know what I am committed to do, which I had no idea of all the terms or anything in this real estate commission. None of it. I had no idea.
Let me see if I can get some answers for you, sir. So, Mr. Conant, I haven't been practicing law for the past 9.5 years, but my real estate experience when I was practicing matches up with what Mr. Booker Walker is telling me, which is the standard rate for commission on real estate in this area is 7%. Is that not the case?
That's my understanding, Your Honor. Mr. Verlin's not here to defend himself. I know that he's had a conversation or two with Mr. Walker, and I know Mr. Verlin would subscribe to, I'm sure, the standard rates of 7%. He's not been able to get in the house, so he can't even put he's not even able to put a final value on what he thinks the house will sell for. So,
well, here's what I'm going to do. I'm going to modify the judgment to provide that the agreement with the Realtor cannot exceed 7%. And I will issue that order. I think that's a legitimate concern that Mr. Booker Walker has as to why we're doing this on a flat fee as opposed to a percentage, which is the going rate. So I think that's a fair question. I'm also ordering him to turn the key over. When would be a convenient?
Your Honor, I don't mean to interrupt you. That's what I did two or 3 days ago, was trying to get him to give him the key.
That's fine.
Only response I got from him to his clerk or himself. Only thing I got from you is bring me the key.
I heard all of that, but I want to make sure, now that we've addressed your concern over the commission rate on the sale of the real estate, I want to make sure that key gets turned over right away so that the realtor can get in.
I would bring it to him today. I would bring it to him or the realtor, wherever he says.
What's your preference, Mr. Conant, that he give the key to you or to the realtor?
I would like to have the realtor have possession of the key.
Okay, give me an address where I can get him, because the place that I've been calling, nobody's there most of the time.
Let me give you his cell phone number, and then you can call him directly.
That'd be fine. All right.
Okay. 262.
262.
2117.
2117.
Yep. I've got one other number for you as well. Okay. That's his cell phone.
Right.
That should get it. The other number is the office, 879.
879.
4682.
4682. All right. Thank you.
And I'm hopeful that we will get the payment that's ordered under the judgment here in the next couple of days to comply with the 30-day requirement that the court had.
What was it?
3,000.
Sure. Yeah. Let me address that, Mr. Conan. You had agreed when we were in court last that you were responsible for your share of the cost of the roof repairs, plus costs that were awarded. So that number was $3,143.01.
Okay. Now, what I agreed to in court was the last time was because they were my brother and sister. I would give them a third of the cost of the roof. Also, but I did indicate that I do not think I was legally could be commanded to give them that money. I agreed to give that. But in addition, the 30-day thing is not something that was agreed to. And I did not hear that being said as it's going to be part of the judgment, that payment will be done at the end of the sale of the house. That will be deducted from whatever the house went for. My third of whatever the proceeds on the house would be taken out of that to take care of that cost of that roof. That's what was the understanding. That was the other thing that I had some discrepancy with. And I called your court clerk, and she said, you cannot address that unless you be in court with the judge. When I received that judgment, which was about a week ago, it's when I got it. And when I saw that, I immediately called your court clerk or secretary, whatever she is, reception. And that's what she told me. Because the agreement was before and it was my understanding. I was at my daughter's house and where I am right now. We both understood to be that it would be done, paid at the end of the sale of the house. It would be included in all the proceeds to be divvied up between the three of us. Which I think is a reasonable way to do it, because I do not have to walk up with somewhere and put up for almost $3,200 and just hand it to somebody. And I think that would be a reasonable and fair and equitable way to do it. We sell the house, then they get their money that I agreed to give them, which I'm not sure that I'm legally obligated to, but I would be willing to give it to them. And I stated that in court the last time because of our relationship, that we are come from the same tree.
All right. Well, I realize the judgment, the way it's written, says you need to pay it within 30 days. The reality is, if you don't pay it, the only remedy, frankly, is for it to be deducted from the sale. There are some other remedies available. I think probably the smartest way to do it is just wait until the property sells, and that can be deducted from your share. Which the judgment specifically says, plaintiffs may list and sell said property, deducting these expenses from defendant's net proceeds from the sale of the property. That gets us to the same point. That's what we're going to do.
Okay.
In the meantime,
right.
Your Honor, we've had to pay $450 to keep the house out of a foreclosure from a tax that was delinquent from 2018. Of course, my plaintiffs, Curtis and Deborah Walker, have paid. Booker Walker didn't contribute any portion of that. So the amount just continues to accumulate, and as the longer this property sits, I don't know if the utilities are on in this property. I don't know if the water and sewer is on in this property. Mr. Booker Walker has had sole control of it. He claimed he had some repairs he wanted to do inside, and when he wouldn't give me the keys. He's had this judgment for 30 days, Your Honor. If he wants to say he's only had it for the last week, that's a bunch of baloney. And
no, that's when I got it. When he came to my, I'm sorry to interrupt you.
I filed a motion over 2 weeks ago on it.
I understand that. That's when I got it.
So.
All right. Well, if any of the owners had to advance money to preserve the property from tax foreclosure, absolutely, they need to be reimbursed for that at the time of closing.
Yeah, well, I'll try to get that to them in the next 30 days. I'll do that. Because when I got the same bill that they got, and I was gonna make arrangements to go down there and pay them the $450 that was due, outstanding on it, 19 taxes, winter taxes.
All right. Well, that's certainly anything that any of the co-owners have to pay. Certainly, they should be reimbursed for at the time of the distribution of proceeds from the sale. So, I will issue an order capping.
Judge, can I say something? Can I say something, Judge?
Sure, go ahead, sir.
Yeah, I'd like to say I wouldn't be surprised if we're back in his position in a short time, because he has been a stick in the mud, and he has been a stumbling block throughout this entire process. And I wouldn't be surprised if he comes up with another excuse why he cannot turn over the keys. And I would strongly wish that you would put some punishment behind if he fails to turn over the keys within a reasonable, proper amount of time. I think there should be severe consequences dealt out to him.
There will be consequences if he doesn't do as he says today. I will tell you his concern about the commission on the sale of the property was a valid concern. He deserved to have an explanation of that, not simply turn over the keys, I'm not going to talk to you about it. he deserved an explanation. He didn't get one. So he's gotten an explanation today. He said he's going to turn the key over today. I expect that to happen. If there is indeed obstruction from this point forward by any party, there will be consequences from this court.
And those consequences would be?
I will decide those at the time because it depends on what the action is, sir. I can't prejudge that.
Okay, but if somebody should refuse to comply and with your order of the court that you're rendering, I would hope there would be some, serious repercussions.
There will be repercussions commensurate with the behavior. That's all I'll tell you.
All right.
And Your Honor, can I ask you one other thing to stipulate one other thing? That my brother and sister stop refusing to take calls from me. I know that's a frustration. I know.
I can't do that, sir. I
just want them to hear that.
I wish you folks would talk. I think that would help. There's obviously a lot of tension here. That's not good for anybody, but I can't fix that. That's something that you folks have to decide.
One more thing.
I just want.
I think we're done today. I don't want to hear anything further.